also add to the court that it was the defendant who alerted the hotel security to his location, which led to his arrest, because in having discovered that he left his cell phone at the hotel, when the hotel called him on another cell phone, he advised them that he was at Kennedy Airport, where he was. They came to return the cell phone ostensibly, and that's when he was arrested. With respect to his fleeing the hotel, it's simply inaccurate, and again, it comes from inaccuracies because of their rush to do this investigation. The record will reflect that he was in the vicinity of the hotel for several hours before fleeing to the hotel after checking out. And the reason he was rushing is because he had a luncheon appointment, and the person who he had lunch with would be able to testify to that. So this theory that he ran out of the hotel and ran to the airport to run away is simply not true. I'd also indicate that he went to the airport on a flight that was booked long before this incident for a meeting in Germany. We have the itinerary, which we can show to the court in electronic format, which showed that he had a flight with Air France at 4 p.m. approximately on Saturday, that he was going there and that he knew he was going there. This has nothing to do with him attempting to flee the jurisdiction. He was going to Germany in connection with his duties on behalf of the IMF. This is an individual with no criminal record. I can't respond to allegations that were made in a foreign country that did not result in any criminal prosecution or consideration. Let me indicate also, Your Honor, that what we have done over the past several days now is, I think, can only be described. We, at the end of the day yesterday, after the lineup was conducted, we were told for the first time early evening that the district attorney's office would seek a warrant to have the defendant examined physically, and photographs would be taken. In order to expedite the process, we executed a consent agreement that permitted the district attorney's office to do this examination without requiring the intervention of a warrant, certainly not consistent with someone who is looking to have something arrangement so that people wouldn't stay here till 1 o'clock in the morning when it became apparent that they would not be finished with the examination. So we're here today. But everything the defendant has done since the time of his arrest has essentially been cooperative. There's no attempt to frustrate this investigation, and the defendant, more than anything else, has a very important incentive to clear his name. And the only way he can clear his name is to fight these charges. The forensic evidence, we believe, will not be consistent with a forcible encounter, and we believe that there is a very, very defensible case, and he should be entitled to bail. With respect to the travel documents, let me submit respectfully that the government has, the district attorney has in its possession the passport of the defendant, the only passport that he has. They asked me whether in addition to that passport, he has an official passport, and we have confirmed with the consulate that he does not have an official passport. In the defendant's office in Washington, Bill Taylor, whose office is in Washington, is prepared as an officer of the court to accept custody of that document and turn it over to the district attorney's office with the understanding that it would not be returned to the defendant at any time without court approval. In addition, we have prepared an affidavit in which the defendant agrees to waive extradition should he violate the terms of his bail and return to France. The district attorney tells me this is essentially not a document that I think is worth a lot, because one, it demonstrates the defendant's willingness to do whatever is necessary to ensure his presence so that he can defend this case in New York without being remanded while he is still remain in New York City without prior approval from the court. Post $1 million bail. He has posted his travel documents. He has no other travel documents. And we submit most respectfully that that is a reasonable bail package. Indeed, it's a substantial bail package. And I want to end by explaining to the court that everything that I have heard is that he is a French citizen, and as a result of no extradition treaty with France, if he goes to France, we will not be able to get him back. That is the principal moving force, in my opinion, that they've argued as to why he should be remanded. Because if it's not that factor in the mix, the fact that it's a serious crime, he's presumed innocent, he has a right to bail. The fact that bail is $1 million is certainly adequate, in my judgment, most respectfully, for this crime, even though it's a serious crime. And to be candid, Judge, our investigation, that as Your Honor knows better than all of us, what happens at a trial down the road is a guess right now. And that's why under the criminal procedure law of the state of New York, everyone is entitled to reasonable bail that will simply assure their presence, not to punish the defendant, and effectively submit that with the affidavit, with the surrender, the travel documents with the fact that the defendant consented to be forensically examined. We asked that the court set bail in the amount of $1 million, surrender of his travel documents with the condition that he resides with his daughter in New York City without prior approval from the court, that he not leave the city of New York without prior approval of the court or without notice to the district attorney's office to the extent he needs to confer with counsel in Washington, and if that's not agreeable, then we'll do everything in New York. His wife is flying in from, I respectfully ask the court to grant him bail that he is entitled to as a matter of law in the discretion of the court.
Well, you know, Mr. Braffman, you're absolutely right. The same rules apply to your client as to anybody else who appears before this court. As you know, you've practiced before me, and you know I'm a fair judge. But at the same time, the only thing that I am here to consider is not whether or not your client is guilty or innocent, but whether or not there is a real risk of flight. That is the only thing that I am allowed under the law to consider, and that is a matter of discretion. And when I hear that your client was at JFK Airport about to board a flight, that raises some concern with this court.
The case is alleged to have occurred at 12 o'clock. We have a consistent itinerary of where the defendant was, who he was with, all during the succeeding hours from 12 noon until he arrived at Kennedy Airport. I had an electronic format proof that his itinerary between May 13th and May 18th had been set for days in stone in connection with his duties on behalf of IMF. The flight that he was about to take at JFK was a flight that had been previously scheduled for days, long before this incident occurred, not a flight scheduled after the incident occurred so that he could flee the jurisdiction. Being on that plane was consistent with where he was supposed to be going, and people were expecting him in a foreign country in connection with his official duties. So this isn't someone who's about to board a plane to flee a crime scene or flee a jurisdiction. This is someone who is alleged to have an encounter at noon. There is a series of meetings that occur consistent with his itinerary between noon and when he gets to the airport. And when he gets to the airport, the call he gets is from the hotel concerning his cell phone. I have more than one phone. And he tells them where I am, and they make arrangements to deliver the phone. That's not consistent with someone who's trying to conceal his whereabouts so he can get on a flight and leave. He had a 10-minute window where he would be gone if that were his intention. And for the price of a cell phone, he would not have said to hotel security, I'm at Air France about to board a plane. If I've just committed a crime at a hotel in New York, the last thing you would want to do is report to hotel security where you are. Their theory is simply inconsistent with logic, and it's inconsistent with guilty knowledge or consciousness of guilt. So I understand what you're saying, Your Honor, but their timeline is simply, they're looking at the end, not where he was up to after this incident is alleged to have occurred.
All right, tell me about the laissez-passer.
The laissez-passer is a document which work that Mr. Strauss-Kahn is involved in. It's essentially a VIP pass. It generally requires that you have a sorry, this is not my phone.
Is that you?
No, it's not my phone. A laissez-passer is a document that essentially assists someone who is considered to have VIP status getting boarded on a plane, getting onto a plane. It's essentially issued by the United Nations. It is not a travel document, to my knowledge, that allows you to travel alone. What I represent to you is not on the defendant's person. It's not in his custody. It was not in his possession at the time of his arrest. They don't have it. We are to go to that office, obtain custody of the laissez-passer, and not give it to anyone other than the district attorney's office. And Mr. Taylor here is in court prepared to make that granted the opportunity to have bail, and there is no indication, nothing, that this defendant intends to flee. What they have looked at with respect to where he was arrested is simply just not fair to say, since he was arrested on a plane about a crime or without living the rest of his life as a fugitive, because that is not a life that he wants to in any way live.
Well, thank you, Mr. Braffman. I think you have made some very compelling points. I think both your points can be both persuasive on either side, as either indicating a greater incentive to flee. Either way, it works both ways. Do you wish to be heard any further?
Just on the whole issue of the state of California wanted him back for a sex crime for 10 years. He lived openly and notoriously in France.
Well, sir,
Everybody knew
I
who he
know
was.
about the agree with Mr. Bracken. All right, this court is going to remand the defendant for grand jury actions, Part F, May 14th.
Your Honor.
Are you serving cross grand jury?
Yes, I am serving cross grand jury notice 19050. Your Honor, the district attorney has invited us to come back to them, at some point if we have a bail package that we think they would be willing to consider. Let me ask the court, would Your Honor change your mind if what we were to add as a component to this bail package is electronic monitoring, an ankle bracelet that would require him to remain in the United States? We have begun to investigate that issue. Unlike the federal system, New York requires us to use an outside vendor. It has to be a vendor that's approved by the district attorney's office. We've made some preliminary calls. It is prohibitively expensive, and I think it's unnecessary. But given Your Honor's decision, I would ask the court if we are able to come to an agreement in principle with the district attorney's office, would we be able to come back here rather than go somewhere else, assuming we can do this in the next 24 hours?
I think you're going to have to go somewhere else, Mr. Grafton. The agreed upon negotiations between the parties is really something that I don't think is appropriate for the court to entertain. You most certainly may go to another venue, appeal my decision here today, but I don't want to have another application about something that the DA is agreeing with you. This is the court's decision. I think that he's a private flight risk, and I remain.
Can the record reflect that I have just served or will serve in writing 19050 notice?
Thank you, Mr. Grafton.
Maybe I have a moment just to look for it. Thank you, Your Honor.
Thank you, Judge.
Your Honor, can I...
So what does this mean?
Officer, take charge.
What does this mean?
What?
Yeah?
May May 20th.
You want to stay here or you want to, while we're here,